Thank you very much, Clarissa. All right, well, I definitely got the short straw this morning because not only did I get to follow Mark, but I also got the EU law slot. That said, I'm a great fan of the EU, and this is one of the benefits of it. This is about the Recast Brussels regulation. Well, the Brussels regulation is a wonderful regulation under which jurisdiction rules are set out, and if you start in one EU court, you can get your judgment enforced anywhere in the EU that you need to go. So, what's this all about? Well, the Brussels regulation has been in force since 2002, and it in turn replaced the Brussels Convention, which dates to way back when. The new Brussels regulation is in force from the 10th of January 2015, and it applies to all court proceedings commenced after that date. It is the first time that they have made substantive changes to the Brussels regulation, and it has become known as the Recast Brussels regulation. Just to make it easy for you to understand, I've done some lengthy slides. Don't worry, I won't go through every last line of them, but the changes are shown in green. So those are the new bits. So first of all, there's an entire slide of green telling you what I'm going to tell you about. So there are various changes made by Brussels Recast, which has been a long time in coming. There have been loads and loads of reports going on and on forever, and various feedback and so on. So there are 4 substantive changes and a bit of tinkering. First substantive change, jurisdiction agreements, how they work. Second substantive change, how to deal with competing court proceedings in the EU, including one of the most fun tactics, which they've got rid of, called the Italian torpedo. Third substantive change, relationship between EU proceedings and non-EU proceedings, trying to make that more effective. Fourth substantive change, bit of tinkering about with the arbitration exception to try and make it work better. And finally, some other minor tinkering, which I will deal with at the end. So looking first at jurisdiction agreements. So the theory is that you have an agreement, and in your agreement you say which court the parties are going to use when they sue one another. Hopefully they won't, and everybody assumes they never will, but in practice, as a litigator, I know they often do. Generally, the policy of the regulation and the previous convention was to uphold jurisdiction agreements. They are a good thing. People have agreed where they can be sued, so they are sued in those courts, and the jurisdiction rules within the regulation mean that that is upheld. So generally, the rule is you must choose and use the chosen court. There are now 2 exceptions to that. One is where you have made your court clause expressly non-exclusive. Now, what does expressly non-exclusive mean? Well, it gives you the option of suing under the regulation where you would have been able to sue if you hadn't had a jurisdiction clause in the first place. Usually that gives you the option of suing the defendant where they are, and sometimes you want to do that. So, for example, if you're acting for a French company, you've got a French jurisdiction clause, but you want to injunct someone in England, it's much quicker to come to the English courts and get your injunction here. That's the option that a non-exclusive jurisdiction clause gives you. So that's been in place for a while. The change made now is that if the jurisdiction agreement is null and void under the law of the chosen court, then that is also a reason that you don't have to choose the chosen court. Might sound pretty obvious that, but the rules now say that. And that is due to the Hague Convention on the Choice of Court Clauses, one of the many Hague Conventions, and that's been dealt with under Brussels Recast. The other change is one that will not be unfamiliar to English lawyers. It's a new rule that the jurisdiction agreement is actually a standalone part of the contract, so that even the contract itself, even if that is disputed, the jurisdiction clause stands alone. It's severable. So, English law's had this for ages. It's now written into the Brussels regulation as recast. So that's the first change to jurisdiction agreements. The second change is the Italian torpedo change. Now, these are the rules that apply when 2 parties fall out. One starts proceedings against the other in one court, say Spain, and the other starts proceedings in another court, say England. And there are rules under the Brussels regulation to decide whose court gets to decide who has jurisdiction. And the general rule is that the person who's gone to court first, the court first seized, that court gets to decide who ultimately decides. So this has led over many years to a problem known as the Italian torpedo. There are Greek torpedoes, Spanish torpedoes, and Portuguese torpedoes, because it all works on this basis. And this is something that I have done, and it's great fun. Someone comes to you, say they're Italians, and they say, well, there's an English jurisdiction clause in my agreement. I'm Italian. I think I'm going to lose under this agreement. I don't want to use the English courts. What can I do? And I say, well, you can start suing Italy. Now, you know that's wrong, don't you? Yes. Okay. The Italian courts will take a really long time to decide that the Italian courts don't have jurisdiction. By the time that's happened, everyone will probably have forgotten about the dispute. It works. In my case, Elizabeth Gloucester had a bad day in the commercial court because she had to say through clenched teeth, but she had no option but to stop in their tracks the English proceedings that the other side had started because we'd start in the Italian courts first. Anyway, I have to say it's not really EU cricket. The courts have long disapproved of it and wanted to get rid of it. So they've come up with a really sensible, sadly, idea, which is that the court first sees rule is disapplied when you've got an exclusive jurisdiction clause. So you can't just show up in another court and say, I'm going to start here, although I've agreed to suing in a different court. So it's a good idea, if a bit of a pity for those of us who enjoyed it. The third change deals with the relationship between non-EU proceedings and EU proceedings. This is a different kind of problem, named after the name case Owusu. That case concerned a fatal accident in Jamaica. Basically, virtually all of the factors were there connected with Jamaica because the fatal accident had happened there. One of the defendants happened to be English. Jamaican courts proceedings were started and there were separate English court proceedings. And the ECJ said, well, one of the defendants is English, so under the Brussels regulation as currently written, the English proceedings have to stay here. We can't stay in favour of the Jamaican proceedings, even though everyone agreed that it would be much more sensible for it to carry on. Forum conveniens was definitely Jamaica. So the solution they've come up with to that particular problem is that the jurisdiction rules also apply when you're dealing with non-EU defendants. And there's various things they've done to it, but the main change is this, that the EU courts, so if this case came in front of the English court again, or another EU court, they now have the option to stay some of the proceedings, an option, so it's discretionary, in favour of non-EU proceedings. But they've set quite a high hurdle for this. So, for example, and this is the main stumbling block, the non-EU proceedings must have started first. That leads to an obvious tactic, which is that you have to get to your claim issued first. So if you ever come across this kind of situation, just go and start court proceedings. Forget pre-action protocols, just go and do it. You need to make sure that your non-EU proceedings have started first if those non-EU courts you think have jurisdiction, because that's the only way you're going to get under that new exception. So that's the third main change. Next, fourth main change, arbitration. Now, arbitration is supposed to be completely outside the Brussels regulation. There's a bit at the beginning of the regulation that says that. So it's supposed to be unaffected, but what happens is that every so often they come into clash. They clash with one another. And this is the West Tankers problem. The West Tankers facts are quite complicated, so I'm going to try and simplify them. A sued B in Italy, even though there was an English arbitration clause. So B starts anti-suit proceedings in England to stop the Italian proceedings, to say, no, you've got to stay in favour of English arbitration. The ECJ says, no, sorry, you can't do that. The Italian courts were first seized, a tactic which may by now sound familiar. So, West Tankers problem. Well, they've thought long and hard of that. Now, from my point of view, the obvious solution here is that actually you do incorporate arbitration clauses into the Brussels regulation. We suggested that when we participated in the consultation. A lot of other lawyers said it too. They haven't done that. What they've done is to leave the arbitration exception completely unchanged, but to put in a really lengthy recital to try and tell everyone how it should work. But there's already doubt as to whether it works. Because if you apply what the recital says to the facts of West Tankers, what you actually get is conflicting judgments, because basically it says that the English action should probably not have been stayed in favour of the Italian action, which means you get two sets of court proceedings carrying on. It's much simpler to actually say arbitration should trump a court clause. They haven't done that. So anyway, there's a lot of doubt as to whether the arbitration tinkering will work. Finally, a little bit of tinkering around the edges. First of all, the abolition of Execrate O, which is not a euphemism for how Henry VIII used to get rid of some of his wives. Execrate O is the step of converting a judgment from one part of the EU into a piece of paper that you can transport to another part of the EU. So, for example, you get your English judgment, you go off to Portugal, as I did a few years ago, and the Portuguese court go through Execrate O and produce another piece of paper and then enforce it. By the time that's happened, 5 years in my case, the company's gone bump and there's no money left. So clearly it's a bit of an irritating step to have to go through. So what they've done is to abolish that requirement. So now in theory you get your judgment of, say, French courts, you turn up in Spain, you show your French judgment to the Spanish courts, and you say, right, enforce that. And that's what they're supposed to do. We have yet to see how it'll work in practice, but that's the theory. Finally, weaker parties. Brussels regulation looks after weaker parties and generally preserves the option of lots and lots of choices of where they're going to sue for employees and consumers and so on. What they've done is to extend those rules so they also apply to non-EU parties. So it gives a slightly wider option for the employees and consumers. Generally, if you're dealing with suing either for or against employees or consumers, they always get to choose. There's not a lot you can do by putting a jurisdiction clause in to stop it. Though sometimes it's a good idea, it might just put someone off. So my final slide is an attempt to actually say, well, any practical changes come out of any of this? And there's only really 2 or 3 of them, because mostly it's about enforcing judgments and tinkering about with that. First of all, when you're drafting, do consider using completely exclusive jurisdiction clauses rather than non-exclusive jurisdiction clauses. That's because of the changes they've made to jurisdiction agreements and the anti-Italian torpedo provisions and so on. But only use an exclusive jurisdiction clause. Do it on a case-by-case basis. Don't change all your precedents. I've seen people trying to change all the precedents. I wouldn't do that, because sometimes you will want the option of suing where someone is rather than the basis of an exclusive jurisdiction clause. So think about it. Always have a jurisdiction clause, always a good idea. Draft your arbitration clauses as tightly as possible to try and protect against someone trying to go around them. Finally, if you're in the situation where there's more than one set of court proceedings, do try and make sure you're first in time. It's always worth doing that. And don't get too hung up on the pre-action protocol if you think you're going to be caught out by any of this. And that's it from me. Thank you.